Welcome, everybody. I see attendees rolling in here. The Chesapeake Region Safety Council would like to welcome you to today's safety webinar, U.S. Supreme Court's Chevron Deference ruling, effect on OSHA and your business. Thankful for our presenters today, Ron Taylor and Haley Degnan with Venable. And I have to say, Ron, I kind of like the title of your PowerPoint better than our title, which is what difference does it make for occupational safety and health matters? See what you did there, Ron. So today, joined with my coworkers, Rod Markley, our Vice President, Chesapeake Region Safety Council, and Dave Medeiros, President of the Chesapeake Region Safety Council. And I'm Kim Beard, I'm Training and Education Manager. Just a few housekeeping items before we get started. There is a Q&A function, questions and answers, on your Zoom. So take a look and find that. It should be on like a dashboard at the bottom of your monitor. Sometimes if you're on your cell phone and you swipe to the left or the right, you'll find the Q&A there on your mobile device. Feel free to pop in questions as Ron and Haley present today. Rod's going to help out by answering the Q&A at the end of the presentation. And if we don't get to some questions today, we'll take your information and we'll try to get back with you with an answer right away. This presentation is being recorded. So if you have to pop out early or you want to share this again with colleagues, just go back to our website at chesapeakesc.org under safety webinars, and we'll have the webinar. And Ron and Haley were kind enough to also offer a copy of the presentation that'll be there as well, just in a couple of days. So that's our housekeeping items, and I'd like to welcome our president, Dave Medeiros.
Well, good morning, everybody. Depending on where you are on the East Coast, you're probably enjoying this deluge of Tropical Storm Debbie. So I came very festive with my tropical shirt today so I could enjoy the storm, and hopefully that's not the power going out. But my name is Dave Medeiros. I'm the president of the Chesapeake Region Safety Council, and I want to welcome everybody here to this webinar today. It's going to be a great opportunity to learn some new things. Our mission at the Safety Council is to educate and influence people to prevent accidental injury and death. And, you know, the old saying goes, there's two things that are for sure in life is death and taxes. But I want to say change is right there with it, because once you get used to something, it changes, and it seems to change from time to time. We get used to following the rules and watching how they're interpreted in a certain way, and all of a sudden, bam, something changes, and now it gets a little bit more exciting. So I would like to say that change is something we should be excited about, and you know what? We've got to learn how to deal with it. It's part of the business. So I want to get started and introduce our two speakers today, because I don't think you want to hear me talk all day. These people got some substance to what they're saying. I'm just kind of filling in for right now. So I want to introduce Ron Taylor. He's an attorney and a partner at Venable, where he chairs the Maryland Labor and Employment Practice Group. Then we have Haley Degnan, and she's an associate in Venable's Labor and Employment Practice Group as well. Ron and Haley advise and defend employers on labor and occupational safety and health matters, including compliance with occupational safety and health regulation. With this team's extensive success rate at an understanding of employment law, we are thankful that they've agreed to discuss this topic with us today. And if you don't get enough today, I think you'll need to show up at our annual Safety and Health Conference on September 26th, where Ron is going to come back again, and I hope Haley will be there as well. And they're going to talk about this subject. You know, it's going to progress over the next so many days or so many weeks, so we'll see where it is then too. So if you don't get enough today, come back to the buffet table on the 26th of September, and you know, you'll get a whole lot of great stuff there. So without further ado, I want to turn it over to Ron and Haley, and thank you all for coming.
Dave, thank you so much, and it's a pleasure to be with everybody on this lovely Friday morning. as you can see from the topic that, and you'll see the slides when they come up in a second, Haley and I decided not to go with all the clever repartee around the decision that we're going to talk about today, involving a doctrine that has existed for approximately 40 years, and it's entitled Chevron Deference. And a lot of lawyers, when they're making these talks, have tried to give it a clever, catchy name like Chevron, the gas is out of the tank. And so we're not going to try and do anything like that, but we are going to try and talk about it. And I need to caution you a little bit because this decision is very new and it changes a doctrine that has existed for 40 years. And so there's a lot that we don't know. I'd like to say that we're better than the prognosticators that you might see on MSNBC or Fox News or CNN, who are often wrong but never in doubt. We're going to try and do better than that. Let me talk a little bit about what it is that we hope to cover today. And Haley, if you could go to the next slide. We're going to talk about a decision that was issued by the Supreme Court on June 28th, entitled Loper Bright Enterprises versus Raimondo, Mr. Raimondo is the Secretary of Commerce. And we're going to try and go through what agency deference, what administrative agency deference is, what the Chevron doctrine was, try to explain to you the Loper decision to the extent that we know its potential right now, and there's a lot we don't know. And then we're going to talk about the impact on OSHA, because what you will see is that, as we'll tell you later, this decision does not mean that OSHA is dead or that disagreements with OSHA will no longer occur. And we're going to try and talk about that in the end. Very fundamentally, what happened in Loper Bright was that the Supreme Court rejected as fiction the notion that Congress intended that administrative agencies interpret and decide what Congress meant in its statutes when the statutes weren't clear. They said, no, that's not a job for administrative agencies. That is a job for the courts. So let's go into and try and unpack what that broad sort of statement means. So very fundamentally, the issue, and Haley, if you could go to the next slide, the issue is who decides what statutes passed by Congress mean when those laws are ambiguous. Under Chevron, a case that was decided 40 years ago in 1984, the Supreme Court had articulated a rule that was subsequently interpreted by most federal courts to require courts to defer to the permissive or reasonable interpretations of the laws that Congress passed instead of making a decision themselves. So even if the court would have interpreted the law differently, they felt compelled under Chevron to defer to the agency's decision about what the law means, so long as it was permissible. And the Supreme Court in the Loper Bright case rejected that notion and said that is an abrogation of the role of the courts to decide what the law is, and rejected, as I mentioned, as fiction, the notion that Congress, when it passes a law that is ambiguous, necessarily intends for an agency to interpret that law consistent with whatever it perceives its mission to be. Before we go further, I want to read a quote. This was a fairly contentious decision, even though it was a 6-3 decision. And you can see from the last, almost the last paragraph of the court's opinion, which goes this way. The dissent, and this is the people who are in the majority of the court talking about those who disagree with the majority. The dissent ends by quoting Chevron. Judges are not experts in the field. That depends, of course, on what the field is. If it is legal interpretation, that has been emphatically the province and duty of the Judicial Department for at least 221 years. The rest of the dissent's selected epigraph is that judges are not part of either political branch. Indeed, judges have always been expected to apply their judgment independent of the political branches when interpreting the laws those branches enact. And one of those laws, the Administrative Procedure Act, bars judges from disregarding that responsibility just because an executive branch agency views a statute differently. Chevron is overruled. That paragraph highlights the stark differences in approach that the 9 justices on the Supreme Court had toward this doctrine that had existed for 40 years, as I mentioned, from 1984. It's a little over a month old now, and lawyers are predicting all sorts of things, but we haven't really seen too many cases. And we're going to talk about some potential impacts here later. But I think you're going to see some pullback in agency action. Certainly, they're going to consider what they articulate more clearly, even in a fairly progressive administration. I think that we can expect litigation to increase, challenges to agency interpretations, asking that courts, rather than agencies, determine what particular things mean. And there's an opportunity for that. Although, as we talk about, it's not always a good thing for employers because litigation means additional costs. So I think there will be some room for employers to decide what they want to challenge or not. For sure, there will be new additional issues that will be available for litigation, and I'm going to talk about some of them later after Haley goes through and tells us a little bit more about the history. That was the first topic on our thing of administrative agency deference. But for sure, there's going to be additional issues that will be litigated now in cases going forward. Some of this, the loss of deference, some of this may create, and this is perhaps a perverse outcome, less certainty for employers, because now you're not going to necessarily see the agency saying that if you like what the agency says, that's okay, but now you don't necessarily know what that is unless and until a court interprets that. Does this mean that every agency rule is going to be subject to this scrutiny? No, it's not. We're talking about deference to laws that Congress passes. Agencies will still be entitled to some deference for their own rules and interpreting their own rules. And the court, even in overruling Chevron, recognizes that the opinions of an agency are entitled to some weight. How much weight is sort of like what a jury or a judge might accord it or might accord to a witness in a trial. Who are you going to believe? That's not going to be quite like that, but it's going to be whose position makes more sense, whose position makes more sense to getting the correct reading of what the law is. But like I say, all of that can create a little bit less certainty for employers because now if it's ambiguous, you need to wait for a court to determine what it means, which, as the Supreme Court has said, is the proper entity to make those sort of decisions on what Congress means, unless, of course, Congress clearly says what it means, which they, you'll be surprised to learn, do not always do. So let's take a step back and let's see how we got to a point where the Supreme Court has issued this very direct, very pointed declaration that it is the emphatic responsibility and province duty of the courts for over 221 years to decide what laws mean and not an administrative agency. So, Haley, let me turn it over to you and we can discuss a little bit of the history of administrative agency deference.
Thanks, Ron. So as Ron said here, to understand where we are now and the impact that the end of Chevron deference may have, we thought it would be helpful to discuss where we've been and really put the court's decision in Loper into context, essentially looking at a couple of decisions on agency deference as different pieces to one larger puzzle. And when we do that, one important takeaway that I'm sure we'll come back to throughout this webinar is that even though the Loper decision has overruled Chevron deference, it hasn't done away with agency deference in its entirety. While we are less likely to hear courts use the term deference, they will still use agency interpretation of law as some form of guidance, and deference to agency interpretation of their own regulation should still be intact to at least some degree. though, as we'll see as we go through these cases, there has been a general trend toward scrutinizing agency interpretation more. So the first case to kind of set the stage for what has come and where we really are now is Skidmore versus Swift back in 1944. It was an action under the Fair Labor Standards Act. Swift and Company was a meatpacking company, which actually was so large that it had its own firefighters. And the issue before the Supreme Court was whether the firefighters' on-call or waiting time was considered work time within the meaning of the Fair Labor Standards Act. And the court held that the agency's interpretation of law was entitled to respect, especially considering its experience and expertise. So one important takeaway from the Skidmore case is while the court didn't necessarily use the term deference, it indicated that at least some low form of deference was being afforded. You know, it used the term respect or using agency interpretation as a guide. And the amount of weight that would be given would depend on multiple factors under the circumstances. But the Skidmore case really set the stage for a couple cases to come that would ramp up the deference afforded to agencies. The next case kind of in this scheme was Bowles versus Seminole Rock and Sand Company. It was the following year. That case involved an interpretation of a price control regulation. And the court held that the agency's interpretation of its own regulation would be given controlling weight unless it was plainly erroneous or inconsistent with the regulation. So Seminole Rock really upped the ante in terms of deference afforded, at least in the context of agencies interpreting their own regulations. The next case kind of following that trend is the Chevron case, which Ron will talk about in greater detail, came in 1984. And that case created a two-step framework in terms of determining what deference would be afforded to agency interpretation of ambiguous law, with a reasonableness standard being afforded to the agency, which again is a pretty low bar and upping the deference afforded. The next case, which continues onward in this trend of greater agency deference, was Orr versus Robbins in 1997. This was another employment dispute. It involved police officers arguing that they should receive overtime compensation under the Fair Labor Standards Act and not be considered exempt from the overtime pay requirements as bona fide executive, administrative, or professional employees. They argued that they did not meet the salary basis test to qualify for that exemption. And the court ultimately gave the agency Chevron deference to its interpretation of the statute and Seminole Rock deference to its own regulation. So Orr is prominent because it essentially affirmed that Seminole Rock level of deference to agency interpretation of regulations. One other reason why the Orr case is important to consider is Justice Scalia actually wrote the majority opinion here, but he later called for the case to be overruled. He felt that agencies ran with Orr deference and really blew it kind of out of proportion of what they expected it to be. So kind of foreshadowing what was to come, the next set of cases, we see a little bit of a curtailment in the deference afforded to agencies, both in their interpretation of ambiguous law and in regulations. So the next case here was United States versus Meade in 2001. The case involved ruling letters by the Customs Service, which set tariff classifications for imported goods. These ruling letters, they don't carry the force of law. They don't go through the notice and comment period. They really only apply to the one entity that they're issued against. And in this case, it was a ruling letter against Meade that their day planners constituted bound diaries and were thus subject to a tariff. Meade understandably objected to this classification, and the court ultimately held that Chevron deference did not apply in this circumstance because those ruling letters did not have the force of law. So the interpretation here did not carry the force of law and was thus not afforded Chevron deference. Essentially, Meade created kind of a one step before you got to Chevron, which curtailed the overall application of Chevron. You had to determine first if the interpretation had a force of law before you would determine what level of deference applied. In a similar vein, a very recent case, Kaiser versus Wilkie in 2019, we saw a curtail of that seminal rock or deference. The case was brought by a veteran who suffered from PTSD and applied for benefits back in 1982. His application was denied, and he petitioned for it to be reopened in 2006, and also that his benefits would apply retroactively. The Department of Veteran Affairs said their interpretation was that there would be no retroactive benefits. The question before the court didn't concern the benefits itself, but whether or deference should be overruled, similar to the question before the court in the Loper decision, which we'll discuss. The court in this instance chose not to outright overrule or deference, but again, it limited its application, holding, quote, it's sometimes appropriate and sometimes not to offer or deference. And basically, the court needs to take that initial step to decide whether or deference will apply in a given circumstance. So with that general overview of where we've come, I'll turn it over to Ron to discuss Chevron in some greater detail.
Terrific. Well, as you can probably see, the court has been wrestling with this issue of deference for 40 years, and this is highly technical. This is a sort of a lawyer's issue, but lawyers have been aware that the court has been uncomfortable with this, and the agencies have been really pushing it. And I got to tell you, almost every case I litigate, if there's any ambiguity, the agencies, including OSHA, assert that their interpretation is entitled to deference. And when you're in the middle of litigation and they pop up and say that this issue is an official interpretation and it's entitled to deference, it's a little off-putting and, quite frankly, a little bit unfair. So let's go back and do a real quick, and I'll try, since we've discussed it a little bit, try and go through a little bit about what this Chevron case is that generated all this sort of angst among lawyers, courts, and administrative agencies. The case involved a question of interpretation under the Environmental Protection Act having to do what is a stationary point of potential pollution. And the issue was whether the agency could consider all of the buildings in a contiguous area, say a plant, that are emitting pollutants, to be a single stationary point or source, as opposed to requiring it to look at each and every building. And so that administrators say, well, we can consider the one location, one establishment, if you want to use an OSHA word, as a stationary source, as opposed to breaking it down to each and every issue. Now, I'm not an environmental lawyer, so I don't know which one would be preferable for employers, but in any event, the court went through and analyzed it as follows. And if you could go to the, so the issue here is this: the Supreme Court developed a two-step law. So we're looking at a rule of Congress, an act, and the first step is to determine whether or not, and go to the next slide if you would, to determine whether or not the law itself is ambiguous. If the law is clear, if Congress has said clearly what it means, then there's no basis for deference. Congress has spoken, and the agency and the courts are required to follow what Congress has said. If, however, the statute is unclear, if it's ambiguous, then the rule that the Supreme Court determined was that the courts are required to uphold the agency's interpretation as long as it is permissible or reasonable. And this is important because this deference required courts to agree with and uphold, that is, an agency's interpretation of an ambiguous statutory provision, even if the court thought that the agency did not have the best reading of the congressional intent. That's a big deal, because if you think about what that means, and the reason for that, the language of the quote that I read earlier from the Loper-Bright decision, is because as a result of this deference, you have administrative agencies that are interpreting what Congress meant, as opposed to courts. And that is the concern that the Supreme Court had and that many other courts have dealt with, but the lower courts don't get to disregard the language of the Supreme Court. So that's the issue. That's the concern. And the fundamental problem with this two-step deference that the Chevron doctrine provided is, as I mentioned, that agencies are interpreting ambiguities in congressional intent. And courts are upholding that, even if they think that that is not necessarily the best or the clearest reading. That was amazingly empowering for agencies because they were in essence assuming the position of both the courts and to some degree of Congress in determining how their laws were to be interpreted. And as I mentioned, I see it in litigation all the time, and we've seen it in other rules where the agency has come out, interpreted something expansively. I'm not saying it's in bad faith, but expansively to support what they view their position to be. And that is the fiction that the Supreme Court was responding to in the quote I read earlier, that Congress must have intended the agencies to have that authority. And the Supreme Court said, no, that's not the case. It has to be courts. So that is a huge step backwards, and it attacks 40 years of troubled, but 40 years of precedent, starting with the Chevron case itself. So let's turn a little bit to get a little bit more detail. Let me turn it back over to Haley for a second.
So talking about the Loper decision in a little bit greater detail here, the two underlying cases were Loper Bright Enterprises versus Raimondo and Relentless Incorporated versus Department of Commerce, both of which were brought by owners of fishing boats who were essentially challenging requirements imposed by the National Marine Fisheries Service, which required fishing companies to pay the cost of monitors assigned to their boats. The companies claimed that the underlying law did not permit the National Marine Fisheries Service to pass this cost on to the companies. In both cases, the lower courts granted summary judgment in favor of the government, and the reviewing courts, which were the DC Circuit Court of Appeals and the First Circuit Court of Appeals, used that Chevron framework that Ron just went through and resolved the case in favor of the government. So for instance, in the Loper case, the court found that while the statute was not entirely ambiguous, the interpretation of the agency was reasonable, at least for the portions that were ambiguous. So the question before the Supreme Court was not on that specific regulation, but whether Chevron should be overruled or clarified. And in a 6-2 decision for Loper and 6-3 decision for Relentless, the court ultimately overruled Chevron deference. The reason for the difference in the opinions is Justice Jackson did not participate in the Loper decision because she was involved previously before her appointment. And the court held that Chevron deference is irreconcilable with the Administrative Procedure Act because pursuant to Section 706 of the Act, which gives reviewing courts authority, courts are to decide all questions of law. Now, the majority opinion called Chevron deference many different things throughout the opinion, including, quote, fundamentally misguided and, quote, unworkable. And it stated that agencies have no special competence in resolving statutory ambiguities, courts do. Accordingly, it was up to the courts, or it should be up to the courts, to do, quote, their ordinary job and exercise independent judgment to determine what the best reading of the law is, rather than just defer to agencies if there's ambiguity. However, one important point to make is that the court ultimately clarified that in exercising this independent judgment, courts can look to agency interpretation as an aid or as a guidance. And what's notable about this point is though the court did not formally adopt that Skidmore deference or that original form of kind of guidance that I discussed earlier, and actually rebukes the term deference in the opinion, it does cite to the Skidmore opinion during those portions of the opinion and incorporates language from the Skidmore decision, or at least language mirroring very closely the language in Skidmore, suggesting that we return to that kind of earlier form of deference. The court also clarified that prior decisions relying on Chevron are not overruled. Justice Thomas and Justice Gorsuch both authored concurring opinions. Justice Thomas really wanted to clarify or underscore that his belief is Chevron violates the separation of powers because in essence, it's taking power away from the courts and giving it to the agencies or the executive branch. Justice Kagan, Sotomayor, and Jackson issued a dissenting opinion, and their argument was that Chevron reflects Congress's intent, that Congress is aware that it cannot write complete regulatory statutes, that there will always be ambiguities, and it would prefer that the responsible agency fill in those gaps rather than the courts. The dissent's opinion relies a lot on the administrative agencies' relative expertise and experience in areas that may be technical. It also chastises the majority for deviating from what was, 40 some odd years of precedent, suggesting that this may lead to greater or a lack of uniformity in federal opinions moving forward. So now we'd like to briefly discuss how the Loper decision may impact agencies such as OSHA. While the impact that Loper has on OSHA is not likely to be markedly different from other agencies, it's worth noting that the authority imparted by the OSHA Act is considered to be very broad, such that agency interpretation of ambiguity has played a fairly prominent role in kind of developing this area of the law as far as occupational safety and health matters. So Ron will go into some greater specifics on the slides that follow, but some general trends lawyers are at least anticipating that we'll see in the wake of Loper include greater legal challenges to OSHA regulations and interpretations moving forward. We saw this a little bit even before the Loper decision, but it's expected that Loper will just give challengers a stronger foothold to raise their challenges to these actions. We may see OSHA issue some more narrowly tailored regulations moving forward. That could be a byproduct of Loper or just its anticipation of these future challenges to try to avoid those challenges moving forward. Forms of informal rulemaking that we've seen the agency use in the past will likely be met with greater challenges or at least greater scrutiny as well. OSHA will not have nearly the same ability to rely on interpretations developed outside of the normal notice and comment rulemaking process, whether that be in the context of litigation or through its interpretation letters. And then finally, we may see kind of a slower rollout in OSHA regulations if that's possible. If OSHA is going to be forced to draft more narrowly tailored regulations, we might see some delay on the front end. If it's going to face challenges, we may see some delay as that process unfolds, or at least on the back end as to when final regulations take effect. And now I will turn it back over to Ron.
Terrific. So Haley, so first of all, let me apologize on Friday morning to subjecting you to what may feel like a law school course, because we're talking about some pretty technical things, and quite frankly, deference has been an issue that lawyers who have specific training struggle with, and so it's even more challenging for people who perhaps don't have legal training or the keen interest in legal decisions. So we wanted to give a couple of examples where this could play out so that you could see two rules that are pending right now and that are also subject to challenge in the courts are OSHA's new walk-around rule, which significantly expands who can be permitted to participate in an OSHA inspection, and also OSHA's heat standard. And I'm going to mention a third one that I didn't include in the slides, but that I think is potentially significant as I was been thinking about this issue, particularly in preparing for this presentation. So the walk-around rule, as the slide suggests, went into effect this year, and it purports to allow third parties who are not employees of the employer and who are not even necessarily representatives of a union representing employers to participate in an OSHA inspection. And the concern is that, plaintiffs' attorneys and other people, community organization people who have an interest in simply being, some people might say, subversive, or to have interests other than workplace safety, to come into an employer's place of business for reasons perhaps unrelated to occupational safety and health or any concerns. And the rule tries to expand on an existing rule and changes it in a way that is concerning to a lot of employer groups, including the U.S. Department of Commerce, because it allows a compliance officer to determine whether or not one of these individuals should be allowed to participate. And part of the concern has to do with, who are the people who are allowed to participate. This rule would purport to require employers to allow trespassers, in essence, people that the employer does not consent to having on their work site, which would be a big change in how things have operated historically. And the issue is, who is an authorized employee representative? To hear some people talk about it, any individual selected by any employee could be an authorized employee representative, which would obviously potentially make inspections a Donnybrook fair and difficult to control. And again, requiring employers to allow people who have no real nexus to their property to come onto their property for reasons that may not be entirely clear to or supported by the employer. And so many lawyers anticipate that the, I'll call it the end of Chevron Deference, may change the way that case is litigated and ultimately may impact whether that rule is appropriate. There's no question that the rule changes OSHA's longstanding rule on who can participate, and also sort of expands fundamentally who is an authorized employee. There are a lot of standards that talk about designated employees. For example, if you think about the access to medical information and exposure records rule of 1910-1020, it talks about designated employees having access to certain exposure records and medical records. A designated employee, though, has a very specific meaning. It's somebody to whom the employee has given written authorization. But the use of the word designated as opposed to authorized means that those concepts are somehow different. And people who are familiar with the National Labor Relations Act, for example, understand that an authorized employee representative is typically a certified union, a union that has been certified by the National Labor Relations Board to be the bargaining agent for a group of employees. And so we're getting to the point where you can see that this difference between authorized and designated employees could create some ambiguity. Under Chevron, the courts would defer to whatever OSHA would say the meaning of authorized employee is. Under the court's recent pronouncement, courts would determine who it is that Congress intended to be allowed to participate in inspections. Now, it's a little bit ambiguous because the act, the OSHA Act, allows the agency, OSHA, to promulgate rules designed to assure that every working man and woman in the United States has safe and healthy workplaces. And so what the Supreme Court's most recent pronouncement is, when you think about it in the context of OSHA, is, all right, what are the boundaries of the authority that was delegated to OSHA? And then, and is that constitutionally permissible? And then, assuming that the answer to that is yes, did the agency conduct reasoned decision-making within the appropriate legal boundaries? So that's why when Haley says that there will still be some deference, is because the agency has been granted certain authority. And as Haley already alluded, Justice Thomas has noted that the grant to the agency is overbroad. I think the intimation from his comments is that it is unconstitutionally overbroad, but we'll have to see there. Similarly, the new heat standard is going to have potential ramifications because it imposes a variety of requirements, including a requirement for paid breaks that may conflict with other statutes and other regulations, even by the Department of Labor and OSHA. So there's a lot of ambiguity there. How far does the agency get to decide, and when does a court decide what the permissible boundaries are? We don't know yet because the challenges haven't, resulted in any decisions, or in the case of the heat standard, it's not finalized yet, so we haven't seen what the challenges may be in the context of litigation. Go ahead to the next slide. As I mentioned, there was another one that I decided not to include in the slides, but that I think is potentially in play now, that the death of Chevron may have an impact on one of OSHA's most widely utilized rules, and that is the multi-employer citation policy. One of the core tenets of the multi-employer citation policy is that employers on a multi-employer job site owe duties to employees. And the agency has interpreted that word employees, to mean any employee, whether or not it is an employee of the employer, and utilizing that, controlling employers such as general contractors, construction managers, or creating or correcting employers, people beyond simply the exposing employer, the employer directly of the employees exposed to a hazard, are amenable to a citation. It seems to me that this is potentially problematic because if one goes back and looks at Section 3 of the OSHA Act itself, employees are defined to be one who is an employee of an employer engaged in the business of the employer. And by using the word engaged in the business of the employer, it seems to create a notion that an employee has to be of the employer, which could have profound impact on the multi-employer citation policy. At a minimum, it may create an issue of ambiguity as to who is an employer subject to citations on a site. There's a lot of case law out there, but this decision is going to breathe some new light into it. Another issue, and this is the subject of the slide here, is the notion of OSHA's existing letters of interpretation, which are sometimes pretty expansive. A lot of times they simply interpret the agency's own rules, but again, those rules are sometimes premised on a statutory interpretation, and hence they may be subject to challenge now, certainly to additional scrutiny. All this results in the possibility of less certainty for employers, and that is a bit of a mixed bag, quite frankly. It's I have heard some people talking about this who say, careful what you ask for, you might just get it. And to a degree, there is something to do with this, although I think the court has correctly decided who it is that decides issues of law. There's still a lot of room for agencies to act and to interpret their own rules, but in the end, it is courts that are going to be deciding what the appropriate boundaries are of congressional enactments. So let me switch back and let Haley talk for a couple minutes on some of OSHA enforcement actions.
Thanks, Ron. So in terms of OSHA enforcement actions, without giving you another history lesson here, there's been a split of authority in terms of deference afforded to agency interpretation that arises in the context of an enforcement action. So when a citation has been challenged, And the split has basically been due to these two cases outlined on the slide here, one of which recognized that deference can come up in the litigation context, and the other, which I spoke about previously, where the court said that interpretations that do not have the force of law should not be given deference. And the takeaway is that, like everything we've spoken about previously, we're likely to see less deference afforded to the agency here, even though courts in the past, at least in some jurisdictions, have relied on deference to affirm citations in certain contexts, including the multi-employer worksite. That was a prominent one. We might also see a lack of deference in other enforcement actions beyond those just related to citations, so such as whistleblower claims. To tie everything together, we wanted to wrap up by discussing what this all means for employers. As Ron mentioned, we recognize that the discourse surrounding Chevron and its possible impact has been, relatively theoretical and academic in nature. So we're hoping to distill it, at least to some degree, down to a day-to-day practicality. So some of these are going to be, relatively obvious, but we'd be remiss if we didn't raise them. Employers at this stage should continue to adhere to all existing, rules and standards, even those that were bolstered by Chevron. The court explicitly said that they have not been overruled. And the same goes for the letters of interpretation, at least at this point. Employers should stay up to date on the legal challenges that currently exist and are likely to arise, especially those where we might see decisions in the recent future. Those will really pave the way for how courts are going to grapple with this new discretion that they are receiving in the wake of Chevron. And be prepared for the possibility of conflicting court decisions. Now that courts have greater deference, we might see a breakdown between jurisdictions in terms of how they interpret or what level of deference or aid they're really taking from these agency interpretations. So
yeah, and that's a good point, Haley, because the normal way that federal courts resolve different conclusions among the federal courts is through appeals up through the circuit courts and ultimately to the Supreme Court to resolve potentially conflicting opinions. And so the end of deference results in the possibility of that sort of a path being followed. I'm not going to go through all of the things that are written on this slide. I'll leave it here, but suffice it to say that employers may be able to utilize the absence of deference to their benefit in negotiating with OSHA in the context of citations that have been issued. And this can be both a benefit and a detriment to employers. It gives you new arguments in terms of trying to leverage a resolution with the agency, but to the extent that you can't get a resolution, it could also result in increased time and expense litigating ambiguous issues. So you're going to be asked or forced to consider what is the cost benefit of challenging a particular agency decision, not unlike the sort of decision that you have to make now. Go ahead to the last slide, and while we're talking about that, well, you go ahead and talk about this one, and I'll make my comment.
Sure. So we alluded to this earlier, but the court declined to grant certiorari, so it declined to hear a case petitioning for it to consider whether the delegation of authority to OSHA was constitutional. And Justice Thomas wrote a dissenting opinion, and the quote here really shows that he's alluding to the fact that perhaps the delegation to OSHA was so broad, it is unconstitutional and there should be an end to OSHA. But because the court has not taken that up, that is not the case as of yet.
Terrific. And so the one last thing to mention is that this is federal court. This is the Supreme Court is dealing with federal statutes. As you know, under the occupational safety and health law, states are allowed to operate their own OSHA programs, for want of a better word, as long as they are at least as effective as the federal OSHA plan, and also incorporate state and local employees. So these decisions, but the decision by the Supreme Court may not have the same effect. It's persuasive, but it's not binding authority on state courts. So when you're in a state plan state, you need to think carefully about whether and how you argue, whether you can and how, if you can, argue that there's no deference entitled, because the state courts may come up with different opinions on their own. So Haley and I have tried to wrap up, and we were enjoying to leave a few minutes for questions. And so we've tried to go through quite a bit. We've only scratched the surface, and we hope that we've given you at least an idea of the complexity of the Chevron deference and the even perhaps greater complexity that might attend to the conclusion or end of Chevron deference as a result of the Supreme Court's ruling on June 28th. But we wanted to leave, without going too far into the details or trying to prognosticate successfully or unsuccessfully what all the ramifications would be. We just don't know for sure now because the doctrine is so new. But wanted to leave an opportunity for y'all to ask us some questions, and to the extent that we're able to, we will try and address them. So let me turn it back over to Dave and Rod.
Yeah, Ron, thank you. There are some questions in the Q&A. I appreciate the presentation that you've given. There's a lot of content there, I know. And we do have some questions that Rod will go over. So I'll just give everyone a moment to find that Q&A button and patch in your questions, and we'll Rod will address them as in order or as we see fit. And then just as a reminder that this is not the last time you will hear from Haley and Ron on this topic. We would love to see everyone attending today again on September 26th at our Safety and Health Conference and Expo. I will pop in the chat the link to register. It'll be a full day of safety and health learning, great raffles, great intel and great food. And we would love to have you. So I'll put some information in the chat for that, and feel free to reach out, everyone, if you have any questions. Rod, I'm going to pass this to you so you can review these questions with your team here.
Absolutely. Thank you. We do have a few questions. They're coming from different directions, so I'm going to do my best to make sure I put the right flavor on the question. The first question in the walk-around rule: if the employees and employer agree to a third party to help represent the company, this is allowed even before the walk-around rule. Is this correct?
Well, so the walk-around rule has to do with who the OSHA inspector allows. If an employer doesn't object to somebody coming and participating in an inspection, then there's not going to be an issue unless the compliance officer thinks that person's participation is disruptive. So if I understand the question, I think that having an agreement about a third party to help is not likely to be an issue. The walk around has to do what occurs and who can participate during the course of an OSHA inspection, as opposed to voluntary compliance officers, voluntary compliance efforts by an employer with its employees or employee representatives.
Okay, thank you. The next question, is this going to impact OSHA's issuing of citation to employers, especially the citation based on the general duty clause or OSHA's interpretation letter published in the past?
Haley, you want to take a crack at that? I have a couple thoughts, but I'll let you go first.
Sure, I can start. The general duty clause is an area where it's come up, and there has been some pontificating, at least, that's an area that will see more challenges, just because of the fact that it's not specific, and it does leave open kind of that area for interpretation. And we will likely to see challenges to letters of interpretation, particularly if they're based on the underlying statute as opposed to an interpretation of the regulation specifically.
Yeah, so the general duty clause in particular is an interesting one. It is not a standard promulgated by OSHA. The general duty clause is actually the language written by Congress. And it's, I think, intended to parallel the common law duty of employers to provide reasonably safe workplace. But of course, the language itself is as clear as mud. Employers are required to provide employment and places of employment that are free from recognized hazards that are causing or are likely to cause death or serious physical harm. I think that theoretically, or at least legally, under the Loper-Bright decision, and for example, the agency would not be entitled to deference in determining what that means. But there is such a large body of law interpreting that I would be surprised if there's a huge shift there. I think if I heard in the question, judges can ignore a reasonable interpretation and, well, I'm sorry, yeah, that may be the next chat question I'm looking at, but I think also that it does potentially impact interpretation letters. You have to go back past the interpretation letter. It's going to be complicated. You have to see what is it they're interpreting. Are they interpreting the act? Are they interpreting the authority granted to them under the act by Congress to determine whether or not that's reasonable? A potential argument, it's one that an employer may or may not raise.
Okay, thank you. And yeah, I think, Ron, the next question you already touched a little bit on. And so wasn't the language already there for courts to overrule an interpretation if it was not reasonable? Now judges can ignore reason or a reasonable interpretation and judge on their own political ideology without justification.
Well, I don't know that I accept the premise of the question. The judges are enjoined to discern the intent of Congress and arrive at the best interpretation of that against longstanding legal principles relating to statutory construction. So we can all talk about people having political ideologies. There are people who think that there are Republican judges, there are Democratic judges, there are conservative agencies, there are progressive agencies, and we tend to focus on that. If the law is applied, then we should get an appropriate decision that is subject to scrutiny under well-established, long-standing requirements.
Yeah, and I'll just add that reasonableness standard, and it's not to say that all court opinions, take this stance, but oftentimes if you get past that first step of the Chevron deference analysis and find that the law is ambiguous, the second step under the reasonableness test is often a foregone conclusion. So I think that's where the distinction with Loper, getting rid of that standard, is really going to have an impact. It's just not giving that kind of automatic rubber stamp that sometimes accompanies the reasonableness standard.
Right, and to the point that you made earlier, and under Skidmore, the courts are entitled to look at what the agency's position has been to determine whether that is should be given weight, whether or not it's persuasive or instructive in reaching the best outcome.
All righty, thank you. Next question, how is it decided what is a matter of law and what is a scientific issue?
Well, that's a legal issue is going to be one of law. This is I'm trying not to sound circular. A scientific issue is going to be one based on fact, and the legal outcome will depend on what the fact is. That's why frequently to decide a scientific issue, you need to have an expert. But the judge listens to that testimony and then determines which position the judge thinks is the correct one. And then they may make a decision. oftentimes we think of as a matter of law. You can only make it as a matter of law if there's established precedent that you can apply. Running a red light, for example, is both a fact issue, but it's also a legal issue because you have to stop at a red light. But there's any number of issues that can go in onto that, whether or not you had an opportunity to stop at a red light.
Okay, and we have questions coming in from other sources, but I feel like this question kind of touches on that question where someone has texted me and said, basically, this could be part of their opinion, but they're saying, if I understand this correctly, judges are smart and would always want to hear both sides of any argument. Therefore, OSHA will now have a stronger, they will have to make a stronger case that a judge would opine in their, or go to OSHA's side. So I guess what they're saying is OSHA now has to present their case and a judge will make the decision if OSHA made that correct interpretation. But they're saying, I guess their opinion is that that's great because judges are smart and they would always want to hear both sides to make a final decision in the argument. So I guess it's not a question, maybe an opinion, but do you agree with that opinion?
I think that it is correct that the agency will be required now to defend its position, to demonstrate that it is an appropriate decision, as opposed to simply relying on a presumption that because they said so, it is the only permissible conclusion.
I think that also speaks to kind of the crux of the Loper decision and the difference between the majority opinion and the dissenting opinion, where the majority is saying, judges, the agency is not necessarily any more of an expert, or the experience the agency has isn't affording that much more than the court can bring to this.
Okay, thank you. Do you think that the decision will place a greater weight to employers' input during the rulemaking process?
It's difficult to foresee exactly how this decision is going to impact the rulemaking process. The Act has a very specific procedure outlined in I think it's Section 5, maybe Section 6 of the Act, that describes how you go through notice and comment rulemaking that permits employers to provide input. I think that the agency will continue to solicit all that sort of information, and then, as it is empowered to do under the Act, to make a decision that is designed to achieve its goal of providing safe and healthful workplaces for employers. And for example, if you think about what I might refer to as industrial hygiene standards relating to toxic and hazardous chemicals, Section 6B of the Act requires OSHA to select the rule that will, to the greatest extent feasible, protect every working man and woman from harmful effects throughout their working career. That's a pretty high standard, and they're still going to have a lot of discretion in determining what that rule is. And even under the court's most recent pronouncement, they're going to look at whether or not that is an impermissible delegation of authority, and then whether the agency acted reasonably within that. It's hard for me to foresee how rulemaking might be changed. I think employers will continue to have some opportunity. Where you might see it is that the agency may be less cavalier about simply ignoring particular positions, whether it's from employee representatives or employers, and arriving at a decision.
Okay, and I have one other question coming through a text. Chevron Deference, will it really impact administrative policy of any agency? For example, the multi-employer citation policy is not necessarily law, but a policy.
As I mentioned during the course of my comments a few minutes ago, I think that it could, because that policy is built on certain legal interpretations. And so the question is whether or not it is a reasonable interpretation of what Congress said in the law to say that an employer who does not employ the people is responsible for employees who are not employees of that employer. So there's an issue, it seems to me at least an argument, that under the definition of employee contained in Section 3(8) of the Act, that the multi-employer rule is suspect. If you are familiar with the multi-employer rule, you know that you can't have a multi-employer general duty clause violation because the language of the general duty clause makes it clear that the duty runs from the employer to its employees. And as a result of that very clear language, the courts have all held, and OSHA agrees, that you can't have a multi-employer citation alleging a general duty clause violation, only the exposing employer. So then the question becomes, and all the case law having to deal with justifying the multi-employer citation focused on the grammatical differences between the regulation relating to construction and other things, and the language of the general duty clause, and parse that language very specifically. But I think that when you go back and look at this definition of in Section 3 that defines employee more clearly, that it's possible that somebody could raise an issue that those cases were wrongly decided, and that the language in the statute says that employees have to be employees of their employer. I don't know. We'll have to see whether somebody picks that up, but it's at least conceivable that people will utilize this potential new argument to challenge decisions. Now, Haley and I mentioned at the top, all of this involves litigation. And so there will be a question whether or not it's cost effective to challenge these things in every case. We don't know. There will be cases where it will be, and a lot of cases perhaps where we won't see change simply because people perceive it not to be cost effective, or because they're used to and comfortable with the status quo.
All righty. Haley, did you have anything to add to that?
No, I think Ron generally covered that.
All righty. Well, thank you. I have no other questions. I want to go back to Kim Beard real quick, and then Dave, because they may be getting questions from other sources as well. But those are all the questions I have. And I'll just end with that, and I'll jump off here and let them talk. But I want to say I'm looking forward. Ron and Haley, I believe you will be at our conference. I'm sure between now and September 26th, we will have some new information about all of this. And we'll look forward to hearing that at our conference on September 26th. So thank you. And Kim, do you have other questions coming in, or Dave?
Nope, I think that you've answered all the questions for now, Rod. And for more information on registering for that conference, open up your chat. There's some information in there for those attendees that are on. So I'm good. Dave, the floor is yours.
Just a quick question. And if a court interprets a state plan regulation in a certain way, will that set precedents in the way that the federal standard is interpreted?
No, those acts are different. And that's one of the reasons, for example, that you can't have a repeat. So if you have a 1926 501 violation in Pennsylvania, and then Virginia OSHA comes and gives you a citation for the same 1926 501 violation, it can't be a repeat because it has to be a violation of the same statute. And so conversely, you're not going to see those interpretations become binding, a state decision binding on the federal. And very typically, Dave, probably, when you get into a state plan, you cite federal cases, and the judges will say, that's persuasive, but not binding authority on me. I may not do it. And I remember once when I was a young associate, more years ago than I care to remember, and probably more years ago than Haley's been alive, a hearing examiner here in Maryland for the Maryland Commission on Human Relations, confronted with a Supreme Court decision directly on point, said, the Supreme Court decisions are not binding on me. And so that you will run into positions like that in state courts where that's nice, it's persuasive, but not controlling. I look to the Supreme Court of Washington State or whatever it is when you're out there.
And that's probably particularly true in certain state plans, like Cal OSHA or in Washington State, where they're more likely to stick to their state plan and maybe detract from the persuasiveness of federal authority.
Yeah, for example, the rule in Washington on multi-employer citations is completely different than the federal rule. They view controlling employers as strictly liable. So if there's a violation by a subcontractor on a site, they view the controlling employer as automatically liable, which is even federal OSHA doesn't go that far. They only require that you engage in reasonable efforts to prevent and detect violations.
Okay, well, fantastic. Ron and Haley, I cannot thank you enough for your time today. I think that you got the wheels turning in my head. I know probably everybody else that's on this thing is going, holy cow, we got some excitement in store for us soon. So thank you very much. I'm going to tell everybody on here, you're going to get an opportunity to hear some more about this, and maybe something will happen between now and the time our conference comes up on September 26th. So we thank you very much. We look forward to hearing from you again, and thank everybody for being here today. And we hope to see you all at the Chesapeake Region Safety Council for some of our great training and education programs. So without further ado, I want to thank everybody for being here today.
Thank you all, and hope everybody has a great weekend.
All right, you too. Thank you.